Hello, my name is Annalise Perron, and for this case study, I will be following a news story surrounding a sacred Indigenous ceremony that was recently interrupted by the RCMP. I will be looking into this story as it relates to relevant legal claims in Canada's colonial history. In May 2020, amidst the COVID-19 global pandemic, armed RCMP officers responded to reports of a large public gathering on the land of the Beardies and Okomasas Cree Nation, located 90 kilometers northeast of Saskatoon. A traditional Sundance ceremony was being held on the First Nations Reserve to pray for a cure to COVID-19. While a public health order which was in place for the province of Saskatchewan at the time of the ceremony limits gatherings to a maximum of 10 people, organizers claim that physical distancing precautions set by the nation's chief and council were being followed. Many of the Indigenous organizers involved took issue with the disruption of the sacred ceremony, especially the presence of the firearms brought by the RCMP, as the Sundance ceremony taking place centers around creation, life, and protecting life, and the presence of weapons on sacred ground opposes this. Chief Bobby Cameron of the Federation of Sovereign Indigenous Nations, representing 74 First Nations in Saskatchewan, illustrates why the interruption was so problematic for the Indigenous organizers, citing that the RCMP should stay off reserve land and that public health orders do not supersede First Nations law and treaties. With Canada's settler colonial history, the disruption of the ceremony calls into question the rights of Indigenous peoples to freely practice their spiritual and cultural traditions in Canada, as protected under Section 25 of the Canadian Charter of Rights and Freedoms and Section 35 of the Constitution Act, 1982. The incident described further pertains to the power of the Canadian government and law enforcement organizations, such as the RCMP, over these activities on First Nations reserves in Canada. On this slide, I have outlined some of the topics that I will address during this presentation. To begin, I will provide some background on various histories that can help in understanding the issues at hand within this case. Indigenous spirituality and cultural practices are diverse among First Nations communities, individuals, and regions. However, it is possible to find common roots. Often, Indigenous spirituality centers around Indigenous ways of knowing or worldview that emphasize a holistic relationship with the Creator, the land, and all of our relations. Furthermore, Indigenous spirituality is often regarded as being inseparable from traditional Indigenous culture and identity. In the context of colonialism, it is important to note the historical and ongoing legacies of colonialism in Canada, including the active suppression and denigration of Indigenous culture, language, spirituality, and ways of life by government and church authorities, and concerted efforts to destroy, subjugate, and assimilate Indigenous peoples. On the bottom right of this slide, there is a diagram that depicts common Indigenous values in a holistic sense, situating these values around the spiritual, emotional, physical, and intellectual directions within the medicine wheel. To understand the significance of the Sundance ceremony's interruption, it is important to understand the ceremony's significance to Cree First Nations culture. The Sundance ceremony is a traditional cultural ceremony performed in honor of the sun, during which participants celebrate the land and its resources, pray for the community and world well-being, and prove reciprocity with the Creator by making sacrifice. The ceremony is central to the identity of Indigenous peoples of the Plains, considered the most sacred of ceremonies by many. Usually the ceremony lasts several days, taking place in a structure called a Sundance Lodge, which can be seen depicted in the image at the bottom left of this slide. In the context of colonialism, the Sundance ceremony was one of the traditional Aboriginal ceremonies forbidden under Section 141 of the Indian Act until 1951. Some communities continued to perform the ceremony in secrecy during the ban, at risk of government persecution. It is also significant that the disruption of the Sundance ceremony occurs on a reserve, as despite the systemic, historical, and contemporary issues that the reserve system presents, for many First Nations peoples, reserves represent a physical and spiritual home where Indigenous history and culture can be nurtured. Reserves are governed by the Indian Act and various sections such as Section 18 and Section 20, and residence on a reserve is governed by band councils as well as the federal government. Finally, to understand this case, one must also understand the complex history between Indigenous peoples and the RCMP in Canada. It is notable that the RCMP was originally established to enforce colonial policy in northern Canada. The organization was also responsible for forcibly removing Indigenous children from their homes and bringing them to residential schools throughout the 20th century, ultimately leading to immense traumas and a devaluing of the Indigenous identity that affects many Indigenous communities to this day. With this history, it is understandable that the relations between Indigenous peoples and the RCMP in Canada remain strained. This relationship is personified in the image on the bottom right corner of the slide of a painting by Cree artist Kent Monkman. I will begin to provide Canadian legal context regarding the case emerging from the original news story by outlining the concept of Indigenous treaty rights in Canada. Treaty making represents a complex history of Indigenous state relations and encompasses agreements between the Crown and Indigenous peoples. It is important to note, however, that while these treaties began as symbols of alliance and cooperation, they have morphed into a settler colonial tool to deny Indigenous rights to land and autonomy on many occasions. In Canada, treaty rights for Indigenous peoples are recognized and affirmed in Section 35(1) of the Constitution Act 1982. The land of the Beardies and Okomasas Cree First Nation, which is covered by Treaty 6 of the numbered treaties, thereby is protected under treaty rights to maintain traditional lifestyle through gathering and ceremony. The image on this slide shows a pipe ceremony during the signing of Treaty 6. The fiduciary relationship between Indigenous peoples and the Crown pertaining to treaty rights represents a means towards reconciliation, by outlining that the Crown has a responsibility to put Indigenous interests first. This concept of a fiduciary relationship first emerged in the landmark Corcoran decision in the Supreme Court of Canada. It is of note for this case that if exercising a discretionary power under the law will affect a specific Aboriginal right, a governmental actor may also be under a fiduciary duty to the Indigenous community's best interest. A governmental actor, namely including the federal government, provincial government, and the RCMP. As introduced in the previous slide, Section 35(1) of the Canadian Constitution Act 1982, along with Section 25 of the Canadian Charter of Rights and Freedoms, recognize and affirm the constitutional rights of Indigenous peoples in Canada, including the right to customary and sacred traditions. In the decision of R. v. Vanderpeet, the underlying legal basis for Aboriginal rights is discussed. It confirms that Aboriginal rights exist and are recognized and affirmed by Section 35(1) of the Canadian Constitution Act 1982. Based upon this fact, the integral to a distinctive culture test is used for determining if an Aboriginal right is being engaged under the Constitution. In order to be an Aboriginal right, an activity must be an element of a practice, custom, or tradition integral to the distinctive culture of the Aboriginal group claiming the right. Therefore, where an Aboriginal community can demonstrate that a particular custom or tradition is integral to its distinctive culture today and has continuity with the practices of pre-contact times, that community will have demonstrated that the practice is an Aboriginal right. This clearly pertains to the Sundance ceremony in question. The decision in Dunaha v. BC also presents some legal precedents relevant to this case. It outlines that to establish an infringement of the right to freedom of religion, the claimant must demonstrate a sincere belief in a practice that has a nexus with religion, and that state conduct interferes in a manner that is non-trivial with their ability to act in accordance with that. The two conditions presented for infringement can be applied to the case at hand to determine if the rights of the Beardies and Okamassis Cree First Nation were infringed upon. In an international legal context, several provisions of the United Nations Declaration on the Rights of Indigenous Peoples directly relate to the rights associated with practicing Indigenous spirituality and associated ceremony. This includes Articles 11, 12, Section 1, Articles 25 and 34, which all affirm that Indigenous peoples have the right to manifest, practice, develop, and teach their spiritual and religious traditions, customs, and ceremonies, and the right to maintain, protect, and have access in privacy to their religious cultural site. While Canada fully endorses UNDRIP as of May 2016, it has yet to be enshrined in Canadian law. Upon the story originally breaking, Saskatchewan Premier Scott Moe responded with a statement saying that there should be no exceptions to the province's public health order, and that other religious and cultural groups have gone to great lengths to modify their gatherings. In a legal context, the no exceptions notion put forth by the Premier could be enforced in Saskatchewan under Sections 4 and 45 of the Public Health Act 1994. However, it is unclear how the rights to spiritual practices provided by Section 35(1) of the Constitution Act 1982 may interact with the Public Health Act. It would take specific judicial oversight of government action within the Canadian court system to determine if the Premier's claims are legally valid. The RCMP responded to the story by saying that although they were on the site, they never asked for the ceremony to stop, and therefore never impeded on the rights of those at the ceremony. Looking into the legal claims of the Beardies and Okamassis Cree First Nation, the First Nations chiefs argue that extreme restrictions were in place for the ceremony to continue and that public health orders do not supersede First Nations laws and treaties, as it is the constitutional right of First Nations groups to sacred ceremonies. While this is affirmed in Canadian law, it can be noted that charter rights are not absolute but rather subject to such reasonable limits prescribed by the law under Section 1. Organizers say interference is reminiscent of the past where traditional ceremonies were banned and RCMP should stay off reserve land. However, in this case, RCMP does have full jurisdiction to enforce the law on the First Nations land. Unlike other religious practices, First Nation ceremonies cannot be separated from the land as they are inherently connected to it. Organizers claim that RCMP had no understanding of the ceremony taking place, although this is not a claim with particular legal relevance based on the background historical context pertinent to this story and the disagreement surrounding the interruptions. It is clear that the RCMP may in fact have not understood the importance of the Sundance ceremony to the Cree culture. To summarize the outcome of the story, as previously mentioned, the ceremony ultimately continued and no arrests were made. Following the news article being published, Canada's Indigenous Services Minister Mark Miller and Prime Minister Justin Trudeau commented on the story, citing that sacred ceremonies should be allowed to continue despite restrictions put in place. A spokesperson for Indigenous Services Canada has said that First Nations leaders are encouraged to consider public health guidelines, and the department respects measures put in place by chiefs and councils. Decisions regarding the cancellation or postponement of cultural practices remains that of the community leadership. The Saskatchewan Premier did reach out to the First Nations community to initiate discussions with health officials about how ceremonies could continue within the limitations of public health orders. It is important in terms of reconciliation for individuals and governments to understand and not repeat the history of denigration and denial of Indigenous peoples' spirituality, cultures, and identities, and to recognize, respect, and accommodate people's Indigenous spiritual practices as a human right for people's dignity and well-being. It is evident after analyzing the story featured in this case study that a lack of understanding surrounding the significance of the ceremony existed from the RCMP and provincial government response. Therefore, the outcome of this case can be seen as an overall negative for Indigenous Canadian relations, contributing to stress placed on these relations in the context of colonialism. journalism. Thank you for listening to my presentation. On this slide, I have included references for all materials used.